So, in this video, we'll discuss question number 54, and that is how are leases made, what is the extent of their duration, and the requisites of a valid notice to quit. And the very answer that regarding this question that we found under section 107 of the Transfer of Property Act, and it is by a registered instrument. So, in case of that, as we found, the following kinds of leases can only be made by a registered instrument as provided under section 107 of the Transfer of Property Act. So, the first kind is leases from year to year, then leases for a term extending 1 year, and leases reserving a yearly rent, so also permanent lease, and other different kinds of leases which form month to month or for a term of a year or less than a year, may be either by a registered instrument or by oral agreement accompanied by delivery of possession. And as regarding duration of leases as provided under section 106, as regarding notice leases from year to year terminable on part of either lessor or lessee by 6 months notice, and also leases from month to month terminable on the part of either lessor or lessee by 15 days notice. So, in the absence of contract or local law or usages to the contrary, a lease of immovable property for agricultural or manufacturing purposes shall be deemed to be leased from year to year, terminable on the part of either lessor or lessee by 6 months' notice, and a lease of immovable property of for any other purpose shall be deemed to be a lease from month to month, which is terminable on the part of either lessor or lessee by 15 days notice. And in that connection, we would like to discuss one important ruling of Patna High Court in 2007 in the leading case Messrs. Basundhara Enterprises versus Indian Oil Corporation Limited and others. The Patna High Court made the observation that the registered lease deed was signed only by the lessor. Neither lessee nor lessors denied the execution of lease deed, creating jural relationship. Subsequently, ratification instrument was signed by both parties, proving that lease was executed by joint endeavor of both parties. In the circumstances, it was held that lease deed was not invalid on the ground that it was initially signed only by one party. A document, however, of this kind is sufficient for attracting the provisions of Section 53 of Transfer of Property Act. So also in another important leading case, Rawat Hardev Singh versus State of Rajasthan, the Rajasthan High Court in 1981 held that if there is a contract to the contrary and a different period of notice is contemplated by the parties, then the requirements of Section 106 Transfer of Property Act relating to giving 15 days notice expiring with the end of the month of tenancy have no application. So, in that connection, we have to discuss the very provisions regarding requisites of a valid notice, and in that case, notice must be in writing, that notice must be signed, and it would be either sent by post or delivered personally, or maybe affixed to a conspicuous part of the property. So, the first requisite of a valid notice to quit is every notice must be in writing, and the second requisite of a valid notice to quit is it must be signed by or on behalf of the person giving it, and the third requisites of a valid notice to quit is that it must either be sent by post to the party who is intended to be bound, or be tendered or delivered personally to such party, or to one of his family or servants at his residence, or if such tender or delivery is not practicable, then it would be affixed to a conspicuous part of the property. So, these are the valid requisites of a valid notice to quit. So, as regarding the very answer to this question, how are lease made? What is the extent of their duration and the requisites of a valid notice to quit? We discussed the very provisions of Section 107, Section 106 of the Transfer of Property Act, and in that connection, we discussed two important leading cases. One is Messrs. Basundhara Enterprises versus Indian Oil Corporation Limited and others. It was decided by the Patna High Court in 2007. So also another important leading case, Rawat Hardev Singh versus State of Rajasthan, and it was decided by the Rajasthan High Court in 1981, and the very requisites of a valid notice to quit. So, this should be the correct and appropriate answer relating to question number 54. And now we'll discuss question number 55, and that is discuss the different ways of termination of a lease of immovable property. So, the very termination of a lease of immovable property that requires as expiry of term, and in that connection we will discuss one important leading case, Sardari Lal Vishwanath versus Pritam Singh in 1978, the very ruling of Supreme Court. So regarding that, a lease comes to an end upon the expiry of the term for which it was granted, where the lease determines by a fixed of time and the tenant continues in possession under the Rent Registration Act, he acquires a status of irresistibility unless there is something to show that he is a tenant holding over mere payment of rent without necessary animus not being sufficient, as it was held by the Supreme Court in this important leading case, Sardar Lal Vishwanath versus Pritam Singh in 1978, relating to expiry of term, which is an essential element of termination of a lease of immovable property, and the second one, that is contingent term. And as regarding contingent term, if the term of the lease is limited conditionally on the happening of some event, the lease is terminated by the happening of such event, as for example, a lease for the duration of war terminates when peace is declared. And now we'll go to the third one, termination in lesser's interest in the leasehold, and in regards to that we'll discuss a leading case also decided by Patna High Court. So the very termination in lesser's interest in leasehold, if the lesser's interest is limited, the lease is terminated with that interest. Thus, a lease granted by a Hindu widow having a life interest would terminate at her death, as it was decided by the Patna High Court in the leading case Raghuvar Singh versus Jitu Mahato in 1923. And now we'll go to the fourth one, and that is merger, when the interest of the lessor and the lessee unite in one person. For example, when a lessee purchases the reversion, there is extinguishment of the lease. And now we'll go to the fifth one, that is relating to surrender, where we'll discuss one important leading case decided by Kerala High Court. So, when the lessee surrenders or yields of possession to the lessor, that is to say, in case the lessee yields of his interest under the lease to the lessor by mutual agreement between them. So the very destruction of a shop room leased out on rent would not automatically terminate the lease and put an end to the landlord-tenant relationship. Meaning of the word building includes site of the building, which is an integral and inseparable part of it. So, in connection to that, we would like to discuss the ruling of Kerala High Court in the leading case George J. Ovungal versus Peter in 1991. It was held that without the site, the superstructure of a shop room on land cannot normally exist. Even in cases where a house or shop room alone is leased out, the site of such house or shop room would ordinarily form part of the subject matter of the lease. And now we'll go to the seventh one, sixth one, that is by implied surrender. So, by implied surrender, lease can be terminated. So, when the lessee relinquishes possession without the previous consent of the lessor, it would be considered that the lease terminated by implied surrender. And now we will go to the next one, by forfeiture, that is to say, in case the lessee breaks an express condition which provides that on breach thereof the lessor may re-enter, or in case the lessee renounces his character as such by setting off a title in a third person, or by claiming title himself, or the lessee is adjudicated as an insolvent and the lease provides that the lessor may re-enter on the happening of such events as we have discussed above, and in any of these cases, the lessor or his transferee gives notice in writing to the lessee of his intention to determine the lease. And now we'll go to the last one, and that is relating to notice to quit as provided under section 106 of the TP Act 9 1882. So, this is another important element of termination of lease of immovable property, so it requires leases from year to year or month to month are terminated by notice to quit under 106 of the provisions as laid down under the Transfer of Property Act 1882. So the very answer that we have discussed regarding question number 55 discuss the different ways of termination of a lease of immovable property, as we have discussed with certain important leading cases and all those conditions under which a lease could be terminated of immovable property, and as relating to that we have discussed all the important and relevant aspects of relating to termination of lease of immovable property as provided under the Transfer of Property Act. So, in our next upcoming video, we'll discuss question number 56, 57, 58, and question number 59 and 56.